Excellent.
Hello everyone, very good evening. Thank you so much for joining this session. Just to give a small intro, Advertising Club Madras is one of the oldest club in India, which was started in 1956, and we actually do a lot of programs. We have series of program coming up this year with a lot of the InsightView series, workshops, ad talks, sports, brand quiz. So please stay connected with us, and if you haven't been become a member yet, please book your membership today itself. And today being the 18th session, it's very typically we always had a session with more of the mainstream of advertising or the data or the digital part of advertising. Today going to be a very interesting session where it is going to talk about the protection and registration of intellectual property. So this is something which we always come across only not as a process of in the beginning itself. Only when we get into some kind of a problem or somebody misuse our property, then we will get to know this. We have two wonderful speakers, and you will have a great session. So over to you, Suraj.
Hey, thank you so much, Bala. Hi, everyone. Good evening. Happy to see all of you back for our 18th session on a Friday at 4 p.m. as usual. So we've got two dynamic and young folks who are from. Let me get the company's name right, please. From Peritum Partners. We've got Karthik Jayakumar, who's a joint managing partner, and Ashwathy Nair, who's the associate at Peritum Partners. Um, there's a lot like Bala said that most of us, at least from the media and advertising side, kind of may ignore, or usually we look into getting advice when we're into trouble. So we thought, why not, give this sort of an insight and information back to our community so that we're a little more proactive with certain things and we make better decisions at an earlier time. So before without taking too much time, I'd like to introduce Karthik and Ashwathy to all of you. Right. So Karthik has over 10 years of experience and has worked at HSB Partners, Amarchand Mangaldas, and Suresh A. Shroff earlier. Karthik has extensive experience in corporate transactional matters, including M&A, legal advisory for startups, private equity, joint ventures, and other advisory services. He also advises clients on various foreign exchange and securities law related matters. Karthik was earlier empanelled on the legal subcommittee of BCCI's Cricket Association of Pondicherry in 2019 and 2020. Ashwathy is enrolled as an advocate with the Bar Council of India in 2017. She graduated from University College London, specializing in international commercial law. She has practiced before the Madras High Court, specializing in niche commercial taxation matters. Post her graduation, Ashwathy worked in OP Jindal University, Delhi, as an assistant professor and assistant dean teaching commercial law to undergraduate and postgraduate students. Ashwathy is currently working as an associate at Peritum Partners, gaining experience in transactional matters including M&A, PE, and VC and advisory services. I'd like to, hand the stage over to Ashwathy and Karthik. Over to you guys.
Am I audible?
Yeah, yes.
All right. I request Karthik to share the slides that we've put together today. So the way that we've structured today's sort of session is for me to take over the introduction, and rather than deep diving into I'm sorry. So rather than deep diving into branding directly, what we had in mind is to take everybody through the different corporate forms, because very often people don't realize that with the type of corporate form that you choose, comes different sort of liabilities and sort of compliances that one is expected to carry out. So what we had in mind is, once we're done taking you all through the different corporate forms, to then give you a basic understanding of what exactly is branding. Because from a purely branding standpoint, branding to a general person who's into advertisements and branding would be very different from how we see branding. So branding from a more sort of larger and a more holistic rather perspective is what we would be looking at. So I would be covering the first 2 points that I mentioned, and Karthik would then be speaking more into what is intellectual property and the different types of intellectual property more specific to the topic that we have in hand today. So Karthik, can we go to the next slide, please?
Sorry. Karthik, could you go on full screen? It's currently in presenter mode. So it's a lot more easier for everyone.
Sure, just a second. I'm sorry. Is this on full screen now?
No, not yet. I think on the top right, if you can see use slideshow, I think it should be there.
Yep, got it. Yeah, thank you.
Perfect.
Thank you. So
Okay.
today, the first bit of discussion is business structures and the relevance that each of these business structures have with regard to intellectual property. So given the current time, so why is it important to understand the different business structures? Because is because of the fact that when you choose a specific corporate form for your business, there are multiple factors that one needs to keep in mind. So what is the nature of the business? How much capital does the company have to sort of pump into the business? What kind of control does one want to have in the business that they want to start? What is the final goal for the business that you have in mind? So multiple factors like this is something that one would consider before actually deciding, okay, you know what, we want to go for a sole proprietorship or whether we want to go in for a partnership. So one always has to keep in mind that there are multiple factors that you need to keep in mind before choosing a form of corporate, business format that you want for your business. So to begin with, sole proprietorships, as the name suggests, it's something that one would choose. It's a choice of corporate form that one would choose if they are somebody who likes to have absolute control over the business. As the name suggests, it's something that one does solely as a person. You're not going to have too many people in the business. So it comes with a lot of pros and cons. And as one would expect, it's very easy to set up as a business form. And on the downside, if anything does happen to the business, then there is unlimited liability and there is no real separation of assets. So if something goes wrong in the business, then, it is a possibility that your own assets might get attached to sort of set off anything that needs to be paid off by the business. So this is the major downside of a sole proprietorship. Now, sole proprietorship is also a choice of format for some people who want to keep things easy, in the sense that when you're starting off, you don't want to have to deal with the legal compliances. If people think that it's too much paperwork, it's too much sort of documents to go through at the very first instance, people choose for a sole proprietorship over the other types of corporate forms. The major sort of advantage is that, as I mentioned, is minimal paperwork. And because it's being managed by a single individual, the decisions are also a lot more quicker compared to the other types of corporate forms that we have today. The second type of corporate form is a partnership, or more often known as a general partnership. Now, this is also a very, I think, more commonly found sort of corporate structure that we find in, say, the startup world, when, people want to just have an idea and want to start pumping in capital into a particular idea that they have. A general partnership is ideally what people start off with. But at the same time, how a general partnership is, the way it's structured, it still has a lot of disadvantages because, you can cap your liability only when it's an LLP, right? But when it's a general partnership, your liability again is going to be unlimited. And the major, I think, problem that we find a lot, at least from our side of the world, which is the legal world, is that very often these general partnerships lead to a lot of conflict of what one partner wants from the other partner. So the end goal is something that when two people don't see eye to eye, the general partnerships sort of fail. So when you have more than two partners in a particular partnership doing a particular business, and from personal experiences as well, general partnerships is fine if you see eye to eye, if you're on the same page as the other partner that you have on board, then it's fine. But the more structured way to go about a business is to maybe have an LLP in place, because when you have an LLP, it's a registered partnership, or the full form of LLP is limited liability partnerships, which, as the name suggests itself, being a partner in the firm, you enjoy the hybrid mode of what a partnership offers, but at the same time, you still have a lot of compliances which companies generally would also have to do, right? So if you ask me, I find LLPs to be in this gray area because they are in a hybrid mode and they get to enjoy the benefits of being a partnership, but also having to deal with, the compliances bit of it, which companies have to do. Now, the best thing about an LLP or having this form of a structure is the fact that you can limit the liability. Now, what this means is, say, if you are putting in 50 lakhs, you can say that my liability tomorrow, if something goes wrong, is going to be limited to that 50 lakhs and it can't be more. So you can basically cap your liability in your partnership deed, and you can make it very clear as to what your outer limits are. So this is the biggest, sort of advantage that you have in an LLP. Now, the disadvantages, as I mentioned, because it's a more hybrid sort of business structure, you have the setting up is slightly more complex than that of a sole proprietorship or a general partnership. So compared to these two business structures, LLPs are considered to be slightly more complex in their nature. Now, the last corporate form or the corporate business structure that we have in, at present today is your company structure. Now, the company structure is further categorized into multiple. You have your non-governmental companies, you have your corporate societies, but the ones that we're going to focus today is the OPC, which is the one-person company, and your private limited company and public limited company. Now, the OPC, interestingly, was introduced only in the year 2013, when I think the MC also sort of realized that there is a need to have, to give the opportunity for a single person running a business to set up, but also not have to deal with people, being non-compliant with, say, payments and other legal things attached to running a business. So the whole aspect of a one-person company was introduced only in the year 2013. And it's been a very, very interesting sort of inclusion into the whole company structures that we have at hand. Because prior to 2013, and the reason I'm saying 2013 is because the Companies Act that we have today is 2013 and the erstwhile Companies Act is of 1956. So the 2013 has introduced a lot of safeguards and a lot of protections compared to the 1956 Act. Of course, there are still a lot of loopholes on the larger structure, but it has also introduced a lot of these sort of corporate structures and things like that, which I think would also promote the whole startup culture that we are seeing today. The second thing is a private limited company, which is also the more commonly found type of company structure. And the private limited company, as the name suggests, is a company with limited liability where shares are very closely held by family or people who are known to the family. So it's a very close structure public can't really, sign up to the shares of a a private company. And the sort of assets that you hold are also sort of very limited compared to a public limited company. Now, a public limited company, which is the last type of company structures that we'll be discussing today, interestingly, a lot of them think that a public limited company means a company that is listed on the stock. Unfortunately, that's not the case. So all all listed companies are public companies, but not all public companies are listed companies. Now, that's a very interesting fact, because you can be a public company, but you may not be listed on the market as yet. So the main difference between a private limited company and a public limited company is the fact that of course, your liability can be limited based on the amount of shares that you're subscribing to. But the main difference comes to the fact that in a public limited company, your shares are offered to the public. Now, there are advantages and disadvantages to both of these structures. But from our topic that we have at hand today, we see that when it comes to larger branding, and when we see that when you talk about branding and IP as such, people are going for a more formalized structure. And formalized as of today starts from point 3 and 4 on the slide today. So you have a lot of brands that start as LLPs and then build their brand to either a private limited company, and then once it's successful, turn into a public limited company. Of course, the transition from one of these corporate firms to the other is also something that we kind of advise with. So over here, what I'm trying to get to is that every business functions with different trade names, and the more popular you get with the public, your branding sort of also takes on from there, and you get a sort of recognition that your brand is sort of working towards. So if we can go on to the next slide, I would very briefly touch on what exactly is branding, right? Now, we put in hours and hours of our time and so much money into our business. But often what we see is that this capital is sometimes not going to get you anywhere. So what we always tell our clients is, instead of putting in that much money, focus on branding. And by branding for us, it means to actually get your regulations and your licenses in place, so that all your money and your hard work that you're putting in is not going wasted. People are not going to take your brand and your business for granted. And for us, branding on the large is a way or a process of creating a unique identity for the business, and that in turn will help you stand out from the rest of the players in the market. So some of the key elements that are sort of connected with branding is your brand name, right? You have a specific name, you have a specific logo. So today, if you see Starbucks, you know that, yeah, this is connected with Starbucks. Now, very interestingly, there was a case that happened, the Starbucks Corporation versus Sardar Baksh Coffee. So the way it was sort of portrayed, people were getting confused, and people were of the opinion that, okay, maybe this is an Indian version of Starbucks. And there was a deception that was created. And this went on to the Supreme Court, and the Supreme Court basically ruled in favor of Starbucks and said that these people have created an identity, and what you guys have done is basically an infringement on their IPR, right? So over here, as I was saying, some of the key elements that one needs to keep in mind when you talk about branding is your brand name, your logo, a specific tagline. Now, when we're going in the mall and we see "just do it," we know that it's Nike. Or say, for instance, if you see a board which says "Taste of India," you know that's associated with Amul. So these are the kind of things that brands do to ensure that their branding is so big, and to an extent where it sort of instills in their consumers' mind that, okay, this particular tagline is associated with this brand. This particular logo is associated with this brand, right? So effective branding can actually help a company build customer relations. It can help sort of command a premium price. So if you know that you're going to get something from, say, Nike, you know that you're going to pay a specific price. At the same time, if you're going to pick up something from say Fila, it's going to be at a specific price. So it helps brands sort of command a premium price, which is very important for businesses because you always need to have the upper hand when it comes to quoting what you think your business is sort of, capable of, right? And the biggest and the most important part of branding is that it helps differentiate from your competitors. Now, why is this important, right? Why is this important is because it gives you that exclusive right to enjoy what you've created. And tomorrow, if somebody wants to harp on what you have created by creating like a, um, like a maybe more less premium version of it, or they're creating like a mock of what you've created, then they're basically using all of that in an unauthorized manner. So if you look at IP in itself, a lot of times rights can be negative and it can be positive. Now, IP as a whole is a negative right, right? It's a negative right because of the fact that, right, I have an IP in my name. It is a negative right for anybody else trying to use what I hold, which is why intellectual property on a whole is a negative right and it's not a positive right. It might be positive to me, but it's a negative right against anybody who is trying to use the right that I hold in my name. So one thing that the legal significance behind branding is the fact that now, say, if I have a trademark in my business's name, it gives my business an exclusive right to sort of use those branding in whatever form that I want, right? It gives the brand the recognition that, okay, this is the trademark and I will be able to use it in whichever format that I want. And as a market differentiation, once people see that mark, they know that it's yours. So on a larger self, it prevents with counterfeiting, it prevents people from sort of hijacking the sort of goodwill that you would have spent hours trying to develop. It builds customer loyalty because tomorrow, and there are several times where they will place these officers in separate cities, and if they find that there is like a counterfeit. I still remember there is this small supermarket next to my house, and for the longest time it was called Lulu's Hypermart. Now, in no way was it actually connected to the Lulu's Hypermart, and they got a notice recently from the authorities saying that this is an infringement and you have to change your name. And very recently, when I was driving past that, now they've changed it to Zulu's Hypermart. So it's these small tweaks that you have to do if at all you are caught, infringing the rights of somebody else. So in essence, branding gives a legal framework that protects a business's intellectual property, reputation, and a market position. By investing in strong branding, businesses can sort of create a valuable asset that you can sort of obstruct another business from using. And you don't have to wait. Just like Bala sir said and Suraj said as well, you don't have to wait for something to go bad before actually taking a step. You can take 10 steps back and think ahead and think of what you need to do for your brand before things actually get bad, and you have to defend in court and all of that. When you start a brand, it's always better to think from a long-term perspective. So with this, I'm done with why branding is relevant. Now I pass it on to my colleague Karthik, who's going to take you through the different forms of IP and why exactly IP as a perspective is important for branding. Thank you.
Thanks, Ashwathy, for setting that context. To maybe walk each of you through the different kinds of intellectual property and what it is in itself, I'm going to try and approach this in as laymanly a manner as I can, so it's easier to understand. When you think of intellectual property, you essentially think of things that you've created with your own mind, which you've put together with your own innovation, your own thought process. You do see a lot of jargon on the screen, which on its own might seem really intimidating to someone who's running a business. But this really includes things that you might create in terms of the logo, the brand name that you have. It could include the technology that you build, your artistic work, any innovation, any invention that you end up creating. Something to also bear in mind is this intellectual property is generally territorial in nature. Though as exceptional scenarios, you may have some things that could transcend territory. But without doing too much of a deep dive into this, just to take you through some of the essentials of what the different kinds of IP that exist are. Some of them are first piece, which is something that almost all of you may have heard of through the course of running your businesses, which is a trademark, which primarily relates to protecting the brand name that you've gotten. It could also extend to your logos, perhaps also a tagline or a slogan. Typically, you try to make this reflective enough of the kind of goods or services that you are putting out in the market. Oftentimes, people think that it's not so critical to get yourself a trademark. Perhaps one of the biggest pitfalls of ignoring getting yourself a trademark registration is somewhere down the line when your business becomes famous enough, you realize that someone else already exists in the market that has already taken the same brand, maybe in the same line of services or goods that you put out, or may not be, but you end up facing significant challenges in that regard. The second bucket is with copyrights, which is essentially to protect any original work that you have of authorship, which includes ad content, jingles, and the likes. The next couple slides will also touch on specific examples of different kinds of such intellectual property. But when you look at a patent, oftentimes people use trademarks, copyrights, patents almost interchangeably. That's almost an everyday experience for us where people come to us thinking they're all the same. But a patent in reality aims to protect inventions as well as innovations. Think of this as you've come across some technology that you've really put together from scratch, or you've improved on existing technology. There's different criteria to what can make a particular product or a process patentable or not patentable. This typically varies from jurisdiction to jurisdiction or geography to geography. Something that may be patentable in the US, for example, may not necessarily be patentable in India. Now, the processes that you would undergo to get any of the IP protection could look significantly different. But that leads me over to what a trade secret is. You would have often heard this and maybe even seen this on a lot of TV series that you watch, that something that you discuss, which is your confidential business information, which probably sets you apart from the rest of the market and gives you that competitive edge, is what you refer to as your trade secret. And of course, you've also got industrial designs, which are essentially any designs that you essentially have that adds aesthetic value to your products, among other things, is what you would refer to as an industrial design. Now, to help the collective understand some of these different kinds of intellectual property with examples, is first, when you look at the brand names and the logos, perhaps the most prominent of the lot is really your Nike's "Just Do It" slogan and the swoosh. This essentially is an example of a trademark that's well protected. It has a primary aim of creating brand recognition and loyalty. At some point, you could see that there is a premium attached to it simply because the goodwill keeps improving with time. Brand recall often ends up happening because of your logos and maybe even because of your brand name. The second part is in relation to patented technologies, which is essentially a simple example of this is from a perspective of, I'm sorry, just give me a moment. Is from the perspective of Dyson's, say, the patented air multiplier fan. You've got several such technologies from prominent brands, which essentially are patented technologies, which is, if I held a patent, I've essentially crafted a form of a technology which is proprietary to me, which I wouldn't want maybe Ashwathy or anybody else on the call to really replicate with ease. And getting a patent will help me protect that technology as being unique to me, as being something that sets the product apart. The third aspect is in terms of copyright content. This, for example, would be if you're putting together a popular film or a TV show, or for that matter, an ad jingle that you've written. You're then kind of leveraging well-known media to attract better attention. Oftentimes you see, even when you're in your personal time, people might be referring to specific dialogues, might be referencing to some TV series. All of this refers to copyrighted content. Now, perhaps not of that level of severity when it's just individuals in their personal time that are referencing to some of these series. I think the trickier part is when you start monetizing using someone else's copyrighted content. And of course, you've a very, very popular piece is around your celebrity endorsements. Take say Ranveer Singh or Oprah Winfrey, any of the celebrities that you would know that really endorse a product. Oftentimes, think of it as if you got, say, Puma and you see Virat Kohli, there's likeness today that people often think about Puma being a brand that's been endorsed by him. Even within my friend circle, it's very normal to see people turning to using brands just because it's promoted by somebody. And I'm sure people may have had that experience as well. The next example is in relation to what you call a trade dress. This essentially refers to, you take say a Coca-Cola bottle, or you take Pepsi, the can of Pepsi, from back in the 90s had a very distinct look. Today has a very distinct look. You see a particular color scheme and the manner in which they productize it. You essentially then automatically think of the brand. The distinctive shape that you've then gotten of the bottle, or for that matter, in terms of how Pepsi put its product out, is what you would call a trade dress. Again, your slogans, taglines, similar to that piece that we touched on the Nike swoosh as well, is just typically also kind of ensuring that it's a little catchy, so that it has a ring to it that you automatically tend to associate it with that brand. Your custom music, jingles, all of these pieces, think of it as you had Kingfisher, you've got Intel inside. These are some really, really popular ones, the Airtel song. All of these would really come under your custom music and jingles. Again, brand recall, primary reason to do that. Oftentimes the collateral advantage that you get out of this, it also stems from the perspective that could be a popular artist that is also behind putting that jingle together. Then you've got your creative ad campaigns. For instance, you think of it as you've got Apple's Get a Mac campaign. Now, these are very, very original advertising concepts that can then stand out so significantly that it gets associated with the brand as a style of advertising in itself. And then you've got your digital and interactive media, which has become of such significant relevance today, where people are creating things in virtual reality, augmented reality as virtual experiences, which then adds to the entirety of what is their proprietary technology. This helps in kind of creating better, innovative and interactive mechanisms of kind of engaging with customers. These are essentially some examples of the different kinds of IP that we've gotten around us. But I'd like to now touch on the impact of having intellectual property on ad businesses, given the specificity to us. This helps add specific value creation to a business, where any brand that has strong IP protection is then in a better position because of the goodwill that gets created, that you can kind of command better premium pricing. And for that matter, just looking at the market conditions today and access to capital can also attract better investment opportunities. And alongside this, that automatically leads you into the piece of a competitive advantage, where if you are able to brand well and you protect the IP that you've created, you can significantly differentiate yourself from a crowded marketplace. And this then automatically feeds into your brand recall, goodwill, loyalty that customers would have. Think of this as the recent past when we had Campo Cola, which had vanished from the market. Significant brand recall because back in the 90s, maybe late 80s, that was significantly celebrated as a brand. That relatability and that sense of belonging and saying, hey, you know what, that brand is back and I've probably got to start using that or consuming that. And of course, the most critical aspect of why we as lawyers exist is on the side of the legal protection. because safeguarding your IP is so critical to be able to enforce. A simple way to explain this is if you've created a brand and tomorrow you would want to, and you see someone kind of making the cheap knockoff of what essentially is your intellectual property, for you to be able to raise your voice, to question that before a court of law, depending on the kind of IP it is, more often than not, you need to have registered IP to be able to have a legal basis to go and take that up in a court of law. Now, this then takes me over to the obvious of what kind of strategies could you possibly adopt to protecting your intellectual property. The first real step that we always advise our clients is in relation to your trademarks. Before, obviously, some businesses that are in existence today that haven't been through the exercise of checking for existence of the brand and hopefully are not in the zone of having received the notice of infringement, you're still in a good place. It's just a matter of evaluating whether the brand is currently protectable. If not, do you want to revamp your brand? Do you want to kind of rebrand? If not, if you're at the place where you're starting your business, it's a good idea to always do that cursory check to see, is this trademark already taken? Is this something that already exists in the market? Is this something that is currently already taken by someone else, maybe a competitor, maybe in an unrelated line of business, to understand whether your trademark, your brand, your logo can actually be protected. This gives you a sense of legal ownership. It prevents misuse and abuse of the fact that you've put in immense hard work in building that brand up. You would not be happy if someone else in the market was to piggyback on your brand and make money behind your back. This essentially is what a trademark registration helps you protect. The second aspect is around copyright registrations. Now, even though you might have some benefits even without registering the copyright, there does exist specific legislation which helps you protect your creative work that is used in advertising to avoid unauthorized reproduction. This, of course, a workaround does exist to this, where if you give due credit to somebody, sure, maybe you've taken that prior permission in utilizing the same, which is what also gives, then leads us over to royalty structures and the likes, which are obviously more complex requirements from situation to situation. But what this now leads us to is just getting your registrations aside of these. Of course, if a product that you've created is something that's patent worthy or design worthy, it's a good idea to also consider any of those other IP registrations from the previous slides. But the critical aspect is this. This is almost comparable to a real life analogy. Think of it as you signed up for a gym membership. That's really the first step of it. Each day you've still got to show up, ensure that you're doing your own piece, your own part of effort that goes into it, which is essentially what is comparable to your monitoring and enforcement, where you're now going to have to keep an eye out to see if someone is actually misusing it. Do you then want to take suitable action against them? Comparable again to our own health, a preventive measure is always better than cure. If you do not have secured intellectual property within a said geography, where you end up facing a challenge is establishing that you are genuinely someone who has created this yourself, perhaps even created this and started utilizing it first. These again are typically the first principles. There can always be exceptions to these first principles as well. But these preventive measures are essentially better addressed earlier on, rather than to look at it at a situation where you find yourself saddled with legal notices stating that someone else really has the same brand as you, but from a long time before. This can then significantly end up derailing the process of running your business. Again, in this day and age of where external capital also is involved, this becomes a lot trickier because investors can then get cold feet wondering how the future of the business would look, simply because the very bedrock of the business, being the intellectual property, has then been shaken. Now, this then takes us over to the piece which is essentially your key takeaways of what you would want to ensure is to invest as early as practically possible in protecting your brand. People often think, today I'm starting my business. Is it worth securing a trademark already? Maybe I should think of it after I've hit my first crore. Maybe I should think of it after I've hit my first 10 crores. But it's always better, even before the first rupee of revenue comes in, for the simple reason that if you put your product or service out with a brand name X, think of it, your brand is already gaining value. If you don't secure that critical intellectual property earlier on, you're exposing yourself to a scenario where there could be potential conflict. And imagine 5, 10, 20 years down the line, of course, subject to how long each IP really stands valid. If you've put in that much time and effort to create value and goodwill to that intellectual property, and you realize later that someone else has now come up and said you're infringing, there's reputational risk to you. There's also the hassle of, I now need to rebrand, but my entire customer base, my client base knows me by X, but then now I'm changing it to Y. It becomes incredibly difficult for you to then change that brand image. Becomes very, very, very tricky in terms of looking at the brand image that you might want to change to. This, one of the fundamentals as well with intellectual property is to always avoid plagiarism. And it's also good to stay away from being inspired by existing brands. Oftentimes you do see, when you look at smaller brands, they do try to set this up as being inspired by, say, someone like a Cadbury's or someone like a Bata. This is essentially then setting themselves up for failure somewhere down the line, because if they do grow enough, or they are within the radar of the larger brand that they are mimicking or essentially plagiarizing from in some form or the other, they then are opening themselves up to an unnecessary legal battle with perhaps someone who has very deep pockets, and that could potentially then end up wiping businesses out in its entirety. This is not where it stops. Just again, like with the human body, just because you signed up to a gym membership once does not mean that you do not need to work out the next year. You're going to have to keep reviewing the progress that you make to look at your intellectual property, to understand how long it remains valid. Do you want to renew it? Are you not using it anymore? Or have you created a sub brand that you may want to protect? These are essentially your key takeaways. Do we look at questions at the moment?
Hey, Karthik. Yes, we can. Lovely. So thank you so much for that, Ashwathy and Karthik. So we've got about 44 participants at this point in time. It's just increasing. It picked up from, I think, 25. In about 5-10 minutes, we reached about 44 people. Okay, I'm going to go with the first question that's sent on chat. To everyone here, please feel free to even come on cam. We'd like to see you all. Let's keep this conversational and get your questions answered however you'd like. Right. So the first question, Karthik and Ashwathy, is who owns the IP in virtual reality?
Sure. I'm going to take this one first. Ashwathy, feel free to add to this. Again, with virtual reality, I think this is a significant complex scenario that you're really looking at, because there are various legal frameworks that would become relevant in this scenario. In the VR world of the virtual reality world, you do see a lot of brands that have presence. For instance, you do see, if you think of it as, say, within the metaverse, you've gotten a lot of brands who've started creating their own replica of, say, think of watches, think of shoes, which would then essentially mean that you cannot be using a brand's logo in a VR game or a VR experience without their permission, and therefore you'd probably see traditional IP laws applying in this regard. You've also got the piece around content creators, which are individuals. You might have companies who are setting up and developing the VR content, who would then hold on to that essential copyright to their original work. And more often than not, think of it as, you may also have the situation of your everyday user. The everyday user may really only hold the minimal IP that is truly proprietary to them. You may have a situation where, for instance, within the metaverse, if you're trying to create a character, you're designing your own personal self in that regard. There's enough and more schools of thought in terms of whether you own the IP to that character or you do not. The underlying being that you're really utilizing the different, say, the shades of color, the hairstyles, the overall body structure of what exists as options given to you from within that specific virtual reality experience. Now, I've tried to address that at maybe 100 feet level. Of course, there is a lot of intricacy to this because it can be significantly situational.
Wonderful. I hope that answered your question, Durga. On to the next one from Kirti Jayakumar. The question is, can a hashtag be considered intellectual property? How do we trace the origins of a hashtag as a small business with limited capacity to search or trace in order to avoid using what another may have already used?
Okay,
I'll
I'll take it up, and I think this is something that I think as any business in this specific space needs to know, because often we find that, okay, we think that maybe using somebody else's hashtag could lead to a violation. So very recently, we'd worked on, I think, a client who wanted to register their hashtag, and they asked if it's possible. Now, very interestingly, I think it's also subject to which part of the world you belong to, because different jurisdictions have different school of thoughts with respect to whether a hashtag can be considered intellectual property. So to answer the first half of the question, it is intellectual property as long as it is something connected with a well-known trademark. If it's a hashtag that can basically differentiate your particular brand with the rest of the brands. So very recently, I think there was a case in the Delhi High Court also, wherein the Tata Airlines, I think, tried to use fly high as a hashtag, and the appellants went forward and said that this is an infringement. And they said that this fly high as a hashtag is not really connected with your brand as an airlines. And it was basically ruled like in favor of the defendants. And then I think it's gone on appeal now. So as long as your hashtag is connected with your brand and it's fully capable of sort of distincting your brand with vis-a-vis the other brands that are there in the market, it is intellectual property and it can be registered separately as a trademark. Now, the second half of the question again is quite interesting, because small brands, and it's a little, I think, difficult to answer also, because even on Instagram, when you go and put like random hashtags, you would find that maybe 100 other posts use this hashtag, or say like these many accounts have used this hashtag.
That's
so
right.
I think the process to this is to be as creative as you can, insert a number wherever possible, or insert things that are sort of distinct to your brand, and try and get it registered as a trademark, because that would count as a word mark. Your hashtag would count as a separate word mark as well. And I think India is slowly seeing the increase with regard to the registration of hashtags. And they're slowly picking up with that of the US and UK, because that's very famous in UK and US. I hope I've answered.
Yeah, hope Ashwathy has answered your question, Kirti. Moving on to the next one. The name says MacBook. I'm sure he has a real name. Should one get the creative ad film campaign and scripts copyright registrations before presenting it to the client?
Sure. I'll take this one, Ashwathy. The context of this essentially stems from two places. One, typically, if you're doing this on behalf of a client, you essentially would have a contract, which is genuinely the basis of doing this. If you're being commissioned to put together an ad campaign as well as a script copyright for somebody, If this is something that is now being put together based on specifics that are given to you, you're essentially then putting that together on the basis of something that's perhaps proprietary to the client. And more often than not, in our experience, these contracts would then call it out that you're essentially creating this ad campaign as work for hire for that particular client. A safeguard layer that you could often try to afford for yourself is to say that this remains your property until that final payment is released to you. But until that point, if this is not the nature of your arrangement, if you're creating an ad campaign or a particular script without them giving you any proprietary information, I would then suggest it's a better idea to have a non-disclosure agreement bare minimum that you put in place with them so that they can't really utilize this, the collateral of what you're putting together to their benefit without you eventually getting remunerated for it. I hope that answers.
Right. Okay, and Kirti has another question, which is, in the social justice space, we sometimes want to localize a campaign run by the UN or a global NGO, which makes promotional campaign materials and makes them available in the public domain. Is prior permission mandatory before localizing the promotional materials through translation? Will not doing so amount to an IP violation?
That is an interesting one. Ashwathy, do you want to take this one or do you want me to?
You can go ahead.
Oh, sure. So in this space, it's reasonable to assume that this is within the public domain, but this again becomes a little situational. It depends on when they put out any of their collateral or their campaign materials, which are available in public domain. You may need to look closely at their fine print to see if you're permitted to utilize it, if there's any restrictions that they've placed on it. More often than not, it may be prudent thought to think that if you don't have an express provision or express permission to go ahead and utilize it, it depends on the nature of the eventual IP that's put out there within the public domain. There are some which say within the statute in itself that a certain kind of IP that's within public domain is then treated as maybe the equivalent. A parallel that I would draw is in terms of open source software. You can either build on top of it or utilize it as it is. But in terms of the mandatory permission requirement, if there is going to be monetizing as an aspect of what you may utilize by utilizing their campaign materials, the conservative view is generally to go back to take their permission. Again, we'll caveat it with that piece of saying it's better to look at their fine print once to see if you may require their prior consent or not. Might not have a straitjacket answer to that, but I guess those are the situational aspects you may need to look at.
Right. We have another question from Divya Rajendran, which is, when brand logos evolve over time, does it mean they own multiple and independent trademarks for all those similar or different looking logos?
I'll take it up.
Yeah, please.
The answer is yes. So the thing is with trademarks, I think the unique bit of trademarks is that, of course, you can get a trademark, but if you have a trademark in your name and you haven't been using it, then automatically when you sign up for a newer trademark with, say, a little more modified version of the logo or whatever, you can prove that this particular logo that you have registered is not in use. So if you are able to prove that it is under the same name and or say, for instance, if Karthik has a trademark in his name and he hasn't been using it for the last maybe 5 to 6 years. If I'm not wrong, the time period is 5 years. If the mark hasn't been used for a period of 5 years, after having got it registered, then you can show to the registry that in spite of getting this mark registered, it's not in use, and you can ask for your mark to get approved. Now the thing is, if you're able to prove that you are in fact the same entity, and with trademarks, it also comes down to the different classes. So if you're in the same class, you would have to prove that this is the same business in a little modified, and all you're doing is a little modification to the existing mark. and I think Karthik can add to this as well. If you're able to prove to the authorities that this particular mark hasn't been in use, then you can go ahead and get yourself a new trademark in the business's name or your name.
Wonderful. Right. So I think
Karthik, do you want to add to that?
No, that was on point.
great. So I just happened to come across your Instagram profile, guys, and I think the audience here should probably do that. I happened to see something which was very interesting that you put out, which was about the Burger King name, where Burger King, the actual Burger King, and the Pune-based brand was that you guys, right? I think you put out that piece of content, if I'm not wrong, right? And about how the Pune-based brand won over the international Burger King because their IP was, I think they registered the brand name in 1992 versus at that point in time, Burger King wasn't in India. So I think to the larger audience, you should follow their page to actually keep updated or keep yourselves updated with things that we deal with on a daily basis. But actually, from a legal standpoint, what happens? That's really cool. But even when what Ashwathy spoke about, two examples recently about Starbucks and the other name, which was very interesting for me personally to understand that there is a legal issue at that point in time for this particular case, right? Very interesting, guys. Thank you so much, Ashwathy and Karthik. And I think we are done with the questions. If you guys have any more, I think you've got a lot of shout outs, both of you on the chat window. Please take a look at it later, whenever you're free. Right, and I request everyone to fill up the survey form. It's just for us to understand how to improve these sessions for our community at a later point in time. So thank you once again, Ashwathy and Karthik. This being our 18th InsightView series session was very insightful from both of you. We look forward to coming with the next session in another fortnight. And thank you once again, everyone.
Thank you. Thanks for having us.
Thank you for having us.
You're welcome.